Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us as we are going to pick up on part 2. Let me just make sure we are all back together. We just lost power and no, it was not kitties. Aaron thinks it might be because of the heat. Let me just make sure I'm all good here. Make sure we come back. There we go. Okay, I'm back. All right. Are you guys back with me? My chat is not. They literally just started up, so we only missed like 5 minutes. So just hang tight. Let's see. All right, my chat isn't being pulled up here. All right, I'm not gonna stress about that. Let's just get you back into the courtroom here. Just want to make sure we have audio, so hold on, guys. Let me just fast forward a little bit here.
Please be seated. Members of the jury, if you would now please give your full attention to Mr. Leary as he makes a closing argument on behalf of the defendant, Mrs. Ali.
Okay. Ladies and gentlemen of the jury, thank you. In the aftermath of October 18th, 2024, Zahraa Ali, in the parking lot, alone, sitting in her husband's truck, had to think to herself, how did I get here? Just 24 hours before, she's planning a trip to go to Iraq to see her sister. Her daughter, Fatima, told you, Mom can be lonely. It can be hard. She missed her sister. She was worried about me. School wasn't going well. I had left Timberline. I was in homeschool, or not homeschool, online school. Clearly, there was conflict with the choices that she was making. She had previously run away. This was my client's last gasped attempt. I have a 17-year-old daughter. Mere months till she's 18. This is my last chance where I have the ability to parent my daughter, hopefully get her in the right direction. Go to Iraq, bring her sister, bring her brothers, spend time with family, be away from dad, continue with school, and hit the reset button. Little did she know that there was another plan afoot. The alarm that would go off at 4 o'clock in the morning that wouldn't wake up the 6-year-old brother. Her third daughter would quietly go downstairs, sneak out the back door into the dark with $100 that she had taken from her mom's purse. No job, no cell phone, no place to go. Apparently had never even told her boyfriend what she was going to do. These are the rash decisions that every parent fears. You want to protect your kids from danger, as the prosecutor acknowledged in closing. It's a tough job. It can suck. You worry, you hope, you pray that they do the right thing, and that when mistakes are made, that they're not devastating, that the child can learn from them. And when they emerge into their 20s, into their late 20s, you can look back, laugh, and cry, and be grateful that you're still together. I'm reminded of the story in jury selection that I think you were all there for, when the guy's talking about his daughter who ran away on a horse. And I asked him, well, where's she now? Oh, she lives next door. That's what one could hope for. But instead, the night of October 14th, or the late afternoon of October 18th, she's sitting in the car. Despite all of her efforts to track down and protect her daughter, she lost her daughter.
That's not us. That's the court feed. So, that's not us. Oh, jeez. What's going on? Oh my God, that's the court feed, you guys. Now the court feed is off. There we go.
We're not going to Iraq. I don't know what's going to happen to my daughter. I certainly don't know what's going to happen to my husband. What she didn't know at that point, she only knew that this was half the story. The freight train was coming. The vice, the state, put her in his target. That's why I'm here. That's why she's here. And that's a piece of why you're here. So, as we look through the evidence, I think it's important to think about the difference of perspective of what my client saw, what my client knew, not just from the witnesses, but from what the video shows. So I'm going to start with the inner city transit bus, Exhibit 38. Maybe. I'm going to unplug it and plug it back in. Oh. I'm going to unplug it and plug it back in. Okay. Okay. Inner city transit bus, Exhibit 38. So, we've heard a lot of descriptions as to where people are, what they're doing. We know definitively, as we piece this together, where my client was at the start of this.
Mr. Leary, it's Exhibit 34.
What did I say? Sorry, Exhibit 34. Okay. So now hitting play.
Can you indicate
At-
the time, please?
Yep, at hitting play at 2:13:08. And this is just a clip, and we see it stop at 2:13:14, and we see the silver and black or silver and blue Honda Element that we will now know contains Ihsan Ali and Zahraa Ali. Now we also know that at the approach of this, that the conflict between, the physical conflict between Mr. Ali and Isaiah Williams has not happened. So when she drives by on Mullen Road, she potentially saw her daughter, her husband, and Isaiah, but there had been no physical confrontation at that point. There we go. Plug it on, plug it in. Yep. Well, here's what I can do. I can talk you through it. Okay, so we see the intercity transit bus. We know that they're approaching. At 2:14, we see the Honda Element coming. And we know, from what I just showed you and the other exhibits, and you'll be able to watch on your own, is that none of the physical confrontation has occurred. So she has no knowledge as to any physical altercation outside of the bus. There we go. Okay, so we now have seen exhibit 34 up until 2:14. So we know that the bus is passing her in the turn lane at 2:14, and she is then about to turn in behind the bus. How do we know that? We know that from exhibit 114, and that is the parking lot surveillance video that shows the bus on Mullen Road and the arrival of the Honda Element. So there we see it turning in behind the bus. And we will see, or not, when you watch it back, when you're deliberating, you will see her run through the parking lot. And the time it takes to go from when the car turns in, and you can time it up to when the fight occurs, to then running across the parking lot and to when she arrives. Okay, so in terms of this discussion about what other witnesses see and what they describe, none of that is she's privy to. She doesn't see the punch. She doesn't see the punches to her husband, the kicks, at least initially until she arrives. All right, so we're going to try something different. And we're going to try to go to exhibit 34. And this will just take me a second to load up. So, when we talk about what Exhibit 34 shows, it is something that I anticipate that you're going to spend a considerable amount of time. Because, fortunately for my client, in 2025 and 2024, we have surveillance video, and we're not relying on the testimony of eyewitnesses. Because, as has been on full display in this case, eyewitness testimony can be all over the map in terms of what people saw, what they perceived, versus what actually happened. When we shot. Okay, so now I have Exhibit 34 up on the screen. Now, as we work through it, we are all in agreement.
Can you indicate what time you have up there, please? Thanks.
So at 2:13:56, we see Mr. Wagner walking across the street. We know a significant amount of physical activity has occurred in terms of Mr. Ali being punched, the dragging, and the bus driver getting out of the bus and coming to the aid, frankly, of Mr. Ali and his daughter. Now, hitting play. Okay, so now we are at 2:13:59. What we see right here, well, I don't know why I use technology. Okay, what we see here is we see Mr. Wagner. We see the individual in the beige sweatsuit, okay? Right above his left shoulder, you can see the head of my client. And Zayla Carter, sweatsuit, oh my goodness. We could see Josh Wagner. Now, Your Honor, can we take a 5-minute break?
Yes, we can. Members
I did
of the
try this
jury, I'm going to
before.
ask the bailiffs to take you back for hopefully just about a 5-minute break.
All right, we are caught up. So we are officially caught up. We're live. So yeah, we lost power. I don't know what happened. We're just sitting here and all of a sudden, boom, we just lost power. Might be the heat. It's really hot here, as it is with most people. Yeah, we got like 97, I think. 96. Pretty toasty. So I don't know if it's everybody's got their ACs going. I mean, I don't know. Anyway, so thank you for bearing with us. Appreciate you guys. The only thing I wasn't able to really connect was my chat, so I can't pull my chat up. Like if you guys, I can't pull your comments up. That's the only thing I didn't connect. But I do appreciate you guys hanging with us and coming back and being with us for what now is becoming part 2. So let's see. Is Fatima in the courtroom? Daisy Jane asks. We're not sure. They haven't really shown. They wouldn't show her anyway. Even if she was there, they probably wouldn't show her. Meaning they never showed her face, right? Even though she's 18 now. But yeah, if she was there, they probably wouldn't show her. Let's see. Katrina, yes, we are back. We lost power. I'm sitting here talking, going through, and all of a sudden, boom, we just lost power. So no idea why, how. It's a beautiful day out. It's hot. It's like 96, 97 out, so it's hot. There's no wind. There's no storms. So anyway, yeah, we just lost power. Bizarre, huh? 93 in Staten Island, Marie says. Woo! Yep, I remember 90 days in the city. I spent a couple smoky smoky evenings with no AC on a 5th floor walk up. Oh yeah, I can feel your pain. If you don't have air conditioning. I was on a 5th floor walk up on 3rd Avenue, and no, actually I was on 18th between 2nd and 3rd. No AC, 5th floor walk up. Yeah, brutal, brutal. I remember it was like midnight and it was still like 90 degrees. Ugh. I don't even think I had fans, to be quite honest. I think I didn't even have a fan. I was such a kid. So yeah. And then you go down to get a Subway and it's like 100 down there and you're just like, oh, you're just literally just dripping, and some people are like passing out and it's just brutal. Heat, flood, storms in southeast Michigan. Michelle says, White Rabbit, you live in far country and it's 90 degrees in Maryland. Oh, farm country. You live in farm country? Yeah. 84 in SoCal, Princess says. Camilla says 70. Oh, they're back.
Working, hopefully.
It's been working while you were gone.
Okay.
Before it would be, I think it's allergic to the jury.
Bring the jury in, please. Please be seated. All right, Mr. Leary, you may continue.
Thank you for your patience. Thank you for being here. You might be surprised I am somewhat averse to using technology, and this only confirms that. Okay, so if we can have the screen. Did work in your absence. Okay. All right, so we have the screen, Exhibit 34, at 13:57, zoomed in, and we see Josh Wagner, his truck crossing the bike lane white stripe, and you will see my client emerge from screen right by the tree, and I'm going to work my way through. So you can see, as I'm going frame by frame, you can see her now walk in front of the tree and extend her hands out. And you can see Isaiah, his hand and face slightly above the bus driver. And we see Mr. Wagner go down. And we are at 14:01, frame 3, and you will see my client then begin to step back. Okay, so we are at 14:04, frame 6. And what you can see is you will see the camo hat of Mr. Wagner. You see the individual in the beige, orangish sweatsuit, male with the backpack. And over his right shoulder, you will see my client standing to get out of the way of Mr. Wagner as he prepares to go down. Moving frame through. Mr. Wagner then goes down. We are at 2:14:07, and you can still see my client. She's very clear here, standing above the right shoulder of the individual in the beige sweatsuit. She is standing as Mr. Wagner goes down to intervene. Okay. So now I'm going to go back to 2:14:07 and hit play. We see Isaiah walking around. We see him momentarily start talking with Haneen. Haneen is filming him. He's upset, threatens to punch her, and that's at 2:14:36 as I stop it, okay? So, we see Zayla Carter and take him away from Haneen as I hit play again. You can see the bus driver just standing around. So we're now at 2:14:49. And we see Isaiah standing up by the tree. We see the third individual, the third adult that's never been named, in the blue rain jacket and a beige hat. We see Mr. Wagner sitting with his hand on Mr. Ali's head, and the situation appears to be calm. So now, if we look at the testimony of witnesses as to what they described what my client did. The situation was over. She didn't appear to be at risk. If she was, I would have brought her onto the bus. Josh described the mom as screaming and crying. She didn't get in my way. She didn't impede. Elijah, I didn't see the adult females. Eric, she just looked like she was watching from the looks of it. Caleb, question, did you see Zahraa Ali attempt to get people to stop punching her husband in the head? Not that I'm aware. Athena, the person whose arm was under the neck and the person yelling, my husband, do you know who that was? I'm not sure anymore. Now, what's interesting is in the state's closing argument, they said that I asked a confusing question and I was the one that elicited that response. I actually watched it last night and went back to it. It was actually on redirect from Ms. Zoe. And if you can all look at your notes and see, when she expressed her confusion, it was in response to a state's question, not the defense. No appear point. She appeared to have her arms wrapped around her upper torso. Isaiah. So the mom, her arm around her neck and her shoulder, her upper chest, as he described. Now, as you described it, you didn't describe it as up against her neck. No, sir. You were concerned about where it could go, not what you saw. Absolutely. The only person who said that she saw my client strangling her daughter was Zayla Carter. Now, that's interesting because what I want to do, I'm going to rewind, and I want you to remember Zayla Carter. In all black, she's got the beige backpack. And what she's really doing is trying to manage Isaiah. She intervenes when he is yelling at Haneen, pulling him away, getting him away from Haneen. She then walks around and walks towards the front, comes back, and then when she sees Isaiah go hands-on with my client, she then intervenes. So you tell me, or you decide for yourselves, as to whether she's actually paying attention to what's happening. So I will go back all the way to the point of where my client and Josh Wagner. Now remember how long my client is standing up before she's even down on the ground with her daughter.
Can you indicate the time, please?
Yep. Thank you, Your Honor. It is 2:13:58 hitting play. So there you see Ms. Carter dive into the pack. In front of the bus driver. She's standing over in the far left behind Isaiah. Haneen starts filming. Isaiah begins to attempt to punch. She pulls Isaiah back at 2:14:37. She's holding on to Isaiah. Isaiah disengages from Haneen. She's having a spirited conversation with Haneen. She then walks away. Back to the whole incident. She then confronts Haneen again, starts pushing her. Pointing, turns to her right, looks to her left. Stopping at 2:15:30. Wasn't watching at all. I mean, I don't blame her. There's a lot going on. She's taking care of Isaiah. Haneen is arguing back and forth with her. State also relies on Mary Wagner. This wasn't intentional. I just happened to stop it at 2:15:30. She has now decided to run across the street and start, saying, "Hey guys, knock it off." Everybody who was around there, nobody said that they saw my client strangling. They said, "Yeah, I saw her grabbing her, saw her holding her." Her daughter, to the police at the hospital that night. My mom was holding me. I was in pain. I had just woken up. I was confused. I tried to speak, but words couldn't come out. My voice was raspy. I wanted my mom to let go of me. I was in pain. She wasn't trying to hurt me. She was protecting me from the chaos. I can't imagine an attempted murder charge where the alleged victim is telling law enforcement that night, "I don't think the person was trying to hurt me." There was chaos. I had just been rendered unconscious from a previous struggle that my mom wasn't involved in. So let's take a walk through the jury instructions. I will be the first to acknowledge, or maybe not even the first to acknowledge, that there is a lot here, okay? Even as somebody who's been doing this, state, defense, the court, there's a lot to this. and the court instructed you that every single instruction matters. There's no one instruction that's more important than the other. Many of the instructions refer to other instructions. A couple of trials ago, I described this as a book, which I think is helpful. If you think of this as kind of, when you read a book, there's an introduction, right? Instruction number 1. It's your duty to decide the facts in this case based on the evidence presented to you during this trial, right? So that's the introduction. Judge talking about, her role. I'm not ever intended to comment on the evidence. If you think I did, don't do that. I don't take that way. How you evaluate evidence, how you assess credibility, lawyers' remarks, objections, evidence. So that really kind of like, okay, basic stuff. So then we talk about jury instruction number 2. As jurors, here's your job. Your duty is to discuss. Number 3, every charge is different, and not a verdict on one charge determines the verdict on the other. Instruction number 4, reasonable doubt. Okay? Everything has its place. So then we get to around 13. We talk about accomplice liability. And then the first one is a 2 convict instruction for Mr. Ali, and that's 15. Okay. So if you're taking notes, you can take notes or you don't have to. But there are 5 2 convict instructions for my client. Attempted murder in the 2nd degree, 2 convict is instruction 16. The assault 2 is instruction 30. Unlawful imprisonment is instruction 35. And I'm going to walk us through some of these. Burglary in the 2nd degree is 46. And violation of the court order is 48. And so we often spend a lot of time talking about those because that is the ultimate roadmap for you as to how you decide, in order, has the state proven beyond a reasonable doubt the following elements? And then it refers to other instructions. So then you get to the end, and then it kind of is a concluding instruction, and it tells you, okay, here's how you deliberate. Select a presiding juror, kind of the order in which you consider things, when you do a special verdict, when you consider a lesser, okay? Now, there will be times where I can imagine a juror saying, well, what about this? The answer to that question, if there is an answer, is somewhere in here, okay? You have every right to ask the court a question and say, as the foreperson would write the question and say, we're asked for the following information. And as Ms. Stone alluded to, we are very limited in the ability to answer those questions. I'm not saying you're not going to get an answer, but very often it will be, please refer back to your instructions, because we have to be careful to not influence your process and give undue attention to a certain instruction. Or if there's a mistake, it will often be clarified. But if you get a response to say, please refer to your instruction, the answer is somewhere in there. And maybe it's unsatisfying, but that's kind of how this works. Okay, so I want to be conscious of time, so I'm going to kind of walk through the 2 convict instructions. Turning to 16, which is attempted murder in the 2nd degree for my client. Okay? Now, if there is a reasonable doubt as to any of these elements, you're done. The state hasn't established beyond a reasonable doubt. And Mr. Kading talked about it a little bit, but the reasonable doubt instruction is instruction number 4. You don't need to turn to it, but I'll just tell you. So that's where it talks about the presumption of innocence. The state has the burden. A reasonable doubt is a doubt, can be singular, for which a reason exists. Okay? So it's not just some doubt that's made up in thin air. You have a reason for it. And your reason can arise from the evidence, testimony, exhibits, or the lack of evidence. Well, how come we didn't hear from this person? We weren't given this, okay? So the question is if you have a reasonable doubt, the state hasn't satisfied its burden. Now, As a principal or accomplice, did she take a substantial step toward the commission of murder in the second degree? Instruction number 11 defines substantial steps. Conduct strongly indicates a criminal purpose. So when she walked up there, was she acting as an accomplice? (13) defines accomplice. Did she aid? More than mere presence and knowledge of criminal activity of another must be shown to establish that a person present is an accomplice. She didn't solicit, she didn't command, she didn't encourage, she didn't request her husband to commit murder in the second degree. Did she aid or agree to aid in his attempt to murder his daughter? Well, the state has acknowledged that there was no plan. There was no, Mr. Ali didn't arrive there with the intent to murder his daughter. So, in the seconds that she walked up there, after seeing her husband being punched, she said to the officers, "I saw that." As she approached, her husband's on the ground, her daughter's on the other side, there's kids in between. Mr. Wagner, coming from the other direction, had a clear view of Fatima. The state would have you believe that in those mere seconds, that she formed the intent to say, "Wow, I'm going to help my husband kill my daughter," by kind of standing around trying to push Isaiah off, who had just been punching her husband in the head. Or that she, while she's holding her daughter, crying, my daughter," in a voice that Fatima described as sad, and told the police that she was trying to protect her from the chaos. In the state's eyes, that's attempted murder. Ladies and gentlemen, this is why we have juries. It's not her decision. It's not the court's decision. It's not my decision. It's your decision. It's your responsibility to hold the state to its burden, that we start from a presumption of innocence. Constitutionally, we walk in this door and we say that my client has not done anything. What did she do? She ran across a parking lot, through a crowd of kids, said that she could see her husband being punched, not 30 times, not 40 times, towards the end, stood there, as we saw in the video when it zoomed in, kind of with Mr. Wagner. Wagner goes in, frees his daughter. If that's attempted murder, we're all in trouble. If a mother going to the aid of her daughter, checking on her husband, who a mob has surrounded and kicked repeatedly and beat, and there's no evidence that she could actually see her face from where she was standing, that in those seconds it's attempted murder, I submit that it's not. Next is the assault 2. Instruction 30. State has to prove. On or about October 18, 2024, the defendant, Zahraa Ali, intentionally assaulted her daughter by strangulation. Isaiah Williams. Her arm was around her neck and shoulder, around the upper chest. Would you describe it as up against her neck? No, sir. Were you concerned about what you saw previously was potentially going to happen again? Absolutely. And that's why you intervened. Not because she was being strangled, but you wanted to break her free and you were worried about her. Instruction 35, unlawful imprisonment. Did mom substantially interfere with the liberty of her daughter? That the restraint was without legal authority, and that the defendant knew such restraint was without legal authority. We revert back to instruction 21. And that is the parental discipline. Discipline isn't really, I think, an appropriate term, because you think of it in terms of somebody who's been bad. But in terms of basically, when do you get to hold your child? So physical discipline of a child is lawful when it is reasonable and moderate, and it is inflicted by parents for the purposes of restraining or correcting a child. She's not trying to correct her. I don't even know that she's really trying to restrain her. I think Fatima described her mom's actions perfectly. She was trying to protect me from the chaos. Wailing, my daughter, that seems to run entirely counter to criminal intent, acting unlawfully. The defendant knew that such restraint was without legal authority. Okay, I want to turn to the burglary. And I know I'm going fast, but you guys have been sitting here all day, and I want to be respectful of your time. Okay. Front page of the instructions. State of Washington versus Zahraa Ali in the case number. Okay? This isn't Fatima Ali versus Zahraa Ali. Daughter doesn't bring charges. This isn't Timberline High School, North Thurston School District versus Zahraa Ali. This is the state of Washington, as represented by these two prosecutors, okay? This is the state that is electing to bring the charges, and they are the ones choosing to bring the charges, okay? There are two, we heard about the no contact or the trespass order that was issued by the vice principal. We can question all day the wisdom of that order, but that order was in place, right? In response to School Resource Officer Howard, I was there basically as a show of force. I handed her the letter, said you can't come to school. She appeared to understand that she couldn't come to school. Okay. And the letter, which you have in evidence, says you could be charged with criminal trespass if you violate this order. If we were here talking about count 4, defendant Zahraa Ali is charged with the crime of criminal trespass, I'd be like, yeah. State has proved beyond a reasonable doubt that she's guilty of trespass. But that's not what they chose to do. They chose to try to, for whatever reason, go for more.
Objection. Sustained.
So, they didn't charge criminal trespass. They're charging burglary. So, criminal trespass is the first piece. I can see. She didn't have permission to be at the school. The second piece is that her entering the school or remaining at the school was done with the intent to commit a crime against a person or property therein. Okay? State in their closing said, okay, there's 3 potential crimes that she could have committed while she was there. She could have run in to try to assault her daughter. Really? Do we really think that she was running in there to assault her daughter? The woman who was holding her, protecting her from the chaos, is then going to run into the school and assault her. Isaiah. Maybe she was trying to assault Isaiah. She had no interest in Isaiah. Haneen was upset with Isaiah. You saw her interacting with Isaiah a ton in this melee. She was upset. There was pushing. There was a threat to punch by Isaiah. That was. She didn't care about Isaiah. Her intent to go into that school was not to assault Isaiah. So then the only question is, The third option is a violation of protection order. So, this is where it gets interesting. The two convict for the violation of the court order in 48. You have the body-worn video, Exhibit 38, from the officer who handed the order to my client. You get to see, and this is the miracle of body-worn video, you get to see what she said. You don't get to rely, you don't have to rely on his interpretation. He says, she's like, are you with the school? No, I'm not with the school. I'm not a school resource officer. What is this? Haneen comes and you can hear them talk in Arabic. State chose not to translate. They have it on video. They didn't bring in an interpreter to say what was being discussed. And she has questions. And he's just like, well, you know, it looks like Dad, Isaiah Williams, this person is. Yeah, I know. So it just basically, I mean, it says, and this is what he's telling her. Don't contact him. Don't call him. Don't email. Don't stalk him. I don't even know if he said stalk, but he said, you know, there's no mention of school. He never tells her school, never tells her 1,000 feet. It's a little curious when the state puts up the exhibit and says, oh, it's a really simple document. We know from Fatima, she says, yeah, Mom speaks English, not nearly as well as Dad. Does she read English? Nope. She gets handed a document, not written in Arabic, doesn't use a language line, doesn't say to Haneen, hey, look at paragraph 4 on page 4, whatever the number is, and make sure you understand that this could be bad if you go to the school 1,000 feet, none of that conversation happens. State, for whatever reason, never called Haneen to say, what conversation did you have with your mom? There is zero evidence. All that you can know is that she was said, don't have contact. So now we go back to the burglary. That the entering or remaining was with the intent to commit a crime against a person or property therein. Did she run into that school to violate? I'm going to run into that school to violate, with the intent to violate a protection order against Isaiah. She wasn't running in there to have contact with Isaiah. She was running in there, my daughter, I saw my daughter run in here. I had it on here, but you guys have it. You guys can watch the video from Timberline High School. She is in there for seconds. She runs in. You hear from the counselor. She gets in, closes the door. She could hear her yell, you know, my daughter, where's my daughter? I know my daughter went in here. What does she do? She lingers for like 2 seconds, turns around, and walks out on her own. She wasn't being non-compliant. She then goes around to the other side. The principal's like, no. We don't know what he says, but we can kind of surmise. Like, no, go, can't be here, go. So in order to convict her of burglary, you have to conclude that she has the intent to commit a crime inside. Not that there was some order that she didn't understand written in English that said she couldn't be within 1,000 feet. That she had the intent to do something other than find out where her daughter is. You know, it's just interesting picking up themes. The state was constantly asking. She was more concerned about her husband. Really? She's holding her daughter. Her daughter gets ripped out of her hands by Isaiah. She runs, and she kind of shuffles towards the school. For somebody who is more concerned about her husband who has just been kicked, and she left him behind, goes to check on daughter, goes into the school. Where's my daughter? Where's my daughter? And the question is well, did she ask her condition? Of course she did. She's trying to find her. So then we go to the final crime, the violation of the court order. Did she knowingly violate a restraint provision of the order prohibiting contact with a protected? I'll be the first to confess, there's a 1,000-foot distance provision in there that if she understood it, she violated it. She wasn't supposed to be there. What evidence is there that she understood it? You hand me a protection order written in Arabic? I don't know what it says. What did she know? She knew that she couldn't call, she couldn't talk, she couldn't have contact with Isaiah. You watch that entire video. At no point does Isaiah say, I'm having a conversation with her. At no time does she reach out and try to have contact with Isaiah. Yeah, she was there. She stayed in the car. She stayed away. Daughter got in trouble. She ran over to her daughter. She went to the school to check on her daughter. She never talked to Isaiah. She never had any contact with him. Now, State's going to be like, well, that's preposterous. Really? Is she there to have contact with Isaiah? She's there for her daughter. Sitting in that car, October 18th. She knows she's different. She's from a different country, speaks limited English, has limited success with navigating the school. She tried to do what was best for her daughter, tried to get her transferred to North Thurston. Couldn't imagine a scenario where her daughter went to school, was running away from a school that she could never even go to. She tried to get in-person school for her and was turned away. Went to the police, tried to get help, didn't work. Went to the school to try to intervene, wasn't told the condition of her daughter, wasn't allowed to see her daughter. Her husband was taken away. No idea that she would have to defend herself and her approach to her daughter and her approach to her husband, and that under a convoluted set of facts and allegations would be accused of attempted murder, assault in the second degree, and unlawful imprisonment. All because, as her daughter described, she was trying to protect her from the chaos. She went into the school to look after her. On the one hand, the prosecutor says she doesn't care about her. She cares more about her husband. But then when she runs into the school to check on her, she picks up an allegation of a fourth charge, a burglary. That could have been a criminal trespass, but no, we're going to
Objection, Your Honor.
Sustained.
has to defend herself against a burglary in the second degree charge. You talk about unconscious bias. My client's different. You can't allow yourself to look at her any differently and reach a decision because she's different. The decision has to be the same, whether or not her child grew up from kindergarten to junior year, played sports, was in the school, the mom was the head of the PTA. She was the head of the PTA. She did exactly like my client did. I don't think she would have been here. And that has to be concerning for each and every one of us. And that's what I love about our system. We have a presumption of innocence, and it is designed to safeguard, protect clients who may be different, to be a check on the government, and to say no, not this time and not this case. If you consider the facts, the circumstances, and the law, there is one verdict that applies for each and every one of the counts. My client is not guilty. I think we can all agree that this is a tragedy. And we certainly could have done things differently. But that doesn't make this a crime. Again, I appreciate you being here.
Members of the jury, we're going to do a brief stand-up. All right, I'll ask everyone to come back to order, please. Members of the jury, because the state has the burden of proof in this case, they have an opportunity to make what is called a rebuttal argument to you. So if you would please give your attention to Ms. Stone.
Thank you.
Ladies and gentlemen, I want to work backwards a little bit. I want to start with Mr. Leary's arguments, and then we'll go back to Mr. Kading. So let's start first with Mr. Leary's arguments. How did I get here? How did, as he says, his client is thinking all these things? Well, you don't know that. There was no evidence of that. There was no testimony of that. You have no indication of that whatsoever. There was quite a bit, actually, of Mr. Leary describing to you over and over again what his client is thinking. You, in fact, have nothing about what his client is thinking. So you don't get to take that as evidence in any way. You get to look at his client's actions, her behaviors, and her statements. And you get to evaluate the evidence in this case based on that, not what Mr. Leary asserts to you his client is thinking during the course of this time. He says that this is her last chance to parent. That's what is probably happening on this day because they're getting ready to go to Iraq. I submit to you, this is in fact her last chance to isolate Fatima. You heard from Fatima, this wasn't just like, oh, you know, I'd rather go somewhere else, somewhere different. She had real fears about going back to Iraq. She had real fears about that. It was a one-way ticket. There was no intent or explanation or indication of return at that time. You heard her say, I'd been before and there were some things I liked about it, but mostly I did not feel safe. And when I have now been pulled from school, I am no longer around anyone. I've had my cell phone taken away. I can't communicate with anyone. I am at home where my parents can see me all the time. I don't have any adults to talk to. And now I'm going to a country where I don't feel safe. There might be family there, but as Fatima has demonstrated throughout this trial, and this evidence has demonstrated, those are not family members that support Fatima. That's not what she's expecting. And there is no return ticket to come home for a 17-year-old who has lived here for a long time. That was very concerning to her based on her own personal experiences, and she expressed that to you. There is, Mr. Leary referred to, going back to voir dire, the juror that talked about what his experience was with that, his runaway child. And let's be very clear, that's not evidence in this case. That's simply voir dire. But notably from that, at no point during his efforts to get his daughter home did you note that he said he strangled his child to do so. The evidence here is what has been presented to you from the witnesses and the testimony. Mrs. because of the evidence, not because of something different, because of the statements of witnesses, because the statements of the people that were present. He says, how could his client know? She just gets there. She has no idea. Yet every single other person that is present says it is obvious, immediately obvious. Not kind of obvious, no, I had to get around to a couple people to see. It is immediately obvious that this child is unconscious and being choked, but somehow mom is the one person of this whole thing that can't see it. She's the only one. She can only see what is happening to her husband, not to anyone else. when we talk about the kids who say they saw it, that's incorrect. Isaiah sees mom strangling with her arms around. She says she can't breathe, and that's part of why he, in fact, reaches down to help her. Athena specifically says mom has her around the neck and is pulling at her around the neck. When you go back and look at those exhibits, you'll see that in one of Noah's still shots, Fatima is sitting there, and you can see mom's arms around her neck. Not in the same way dad's are, it's a different hold, but it is around her neck, and Fatima tells you she can't breathe. You will see also that at some point it looks like she's being pulled back and her leg is popping up because mom is in fact pulling on her. Athena said very clearly that mom is grabbing at her to get her, and it is overly aggressive. That was Athena's description of mom grabbing her by the neck. She says Fatima is flailing her arms around, and mom puts her arms around her neck. She says ultimately, when Mr. Leary was talking about confusing Athena, Miss Zos asked on redirect, "You sound like you were confused," because Mr. Leary, do you recall, he went through second by second on the video with Athena and said, "Well, do you see it here? Well, do you see it here? Well, do you see it here?" And Athena said, I know it was mom, but now that you show me the video, I can't see where mom is on the video, but I know what I saw in person, and I know it was mom, but now I guess I'm confused. And Ms. Zoe came back on redirect and said, "Are you confused because you remember it being mom, but now you can't see the video specifically?" Yes. So in fact, it was Mr. Leary that asked her second by second, but Athena Rich told you, in fact, that it was mom, and she was not confused about that. We heard Fatima say, "I don't think she was trying to hurt me," later at the hospital. But what she immediately says, and you heard Liz Robinson testify, that when she comes in, "My dad was trying to kill me, my dad was trying to kill me, my mom was choking me." That's what Fatima reports to Liz Robinson. That's what Liz Robinson testifies to. And you remember when Fatima testified, she said, I didn't think she was trying to choke me at the time. And I said, "Fatima, do you want to believe your mom is trying to kill you? Do you want to believe your mom is trying to strangle you?" "No, I don't." That is an absolutely reasonable response from a 17-year-old whose dad just strangled her into unconsciousness and a seizure. It is an absolutely reasonable response to want to believe that at least one of your parents is on your side. Absolutely reasonable. Doesn't mean that's what mom was doing. It means that that's what that child is hoping at her core, that there is a parent that is looking out for her. And that is not what happened on this day. Mom has just as long on scene as Josh Wagner. Mom actually has longer on scene as Josh Wagner to see what is happening. And when you look at that video, you see that she does not provide any aid at any time to her child. Zero aid. When she's standing there and counsel talks about her saying, my daughter, that is the explanation for, that's her expressing her concern. But at the time that that is actually happening, remember what is actually going on at that time. That is when Haneen and Isaiah and Zayla are having that confrontation, because Haneen comes in late. Haneen doesn't see anything that's happening. Wagner is already down, holding her dad down when Haneen gets there, and straight in puts the phone in Isaiah's face. And again, why is that? Because in this scenario, for this family, Isaiah is the bad guy. In every version of everything that you have heard, that complaint has been about Isaiah. So when defense counsel says, she doesn't care about Isaiah, she doesn't, whatever, he's whatever, that's not true at all. Every chance that she gets, Zara and Haneen provide information to law enforcement about how this is all Isaiah's fault. She says, go, go, go. He said, go, 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 and he took her. You know these people. They're rude. That's what she says. Those are their statements consistently. So this idea that somehow Isaiah doesn't matter, he's of no consequence, so she's not going in there to violate any orders or assault Isaiah or do anything to Isaiah. She absolutely is. She knows she's not supposed to be there. She knows she's not supposed to have contact. She just doesn't care because she does not like Isaiah, and she says that repeatedly. She says it to Officer Hang. She says it to Officer Bell. She says it to Officer Chavez over and over again. And keep in mind, this is the same Isaiah that in September, just 4 weeks prior, she's already had some kind of interaction with at the school that has gotten her trespassed in the first place. So we already know that she is in fact the focus. We know that she is the focus of Zahra's behaviors and actions and ire. And this is an extension of that. And she thinks that he has Fatima and she's going to get him back from Isaiah. So during the course of that interaction then, when Haneen comes in and puts the phone in Isaiah's face, and all of a sudden, now, Zahra is saying, my daughter, my daughter. Who is she actually saying my daughter about? Is she saying my daughter about Fatima? Or is she saying my daughter about Haneen, who's in the middle of that interaction? We don't know. It could be either one of them. But her follow-on behaviors do not demonstrate this overwhelming concern for the condition of Fatima. It demonstrates a concern for getting her back as if she is a possession, because she wants to isolate her and control her. She doesn't want her talking to law enforcement. She doesn't want her making statements or any more statements about what is going on. When we look at her arrival at the school, how does she know to come running? According to Mr. Leary, she arrives at the school. She hasn't seen any kind of conflict happening. So presumably, Dad has called her and said, hey, I see her. She's here with Isaiah. She's at the bus stop. I'm going to go get her. Presumably, that's what happens, because how else does she even know to come to the school? There's no way for her to know that. And how does she know when the car parks to get out and start running for that scene? Because I submit to you, Dad has indicated to her in whatever way they communicate about discipline of their children that he is grabbing Fatima and it's going to be a fight, and he knows that. And she is running to assist. And when she gets there, that is exactly what she's doing. She doesn't have to know that he has the intent to kill Fatima prior to, but certainly if you run in and somebody is in the middle of strangling somebody and your first instinct is to remove the people who are trying to help your daughter, that is a substantial step as an accomplice to aid by presence and act. When counsel says, why didn't we call Haneen? Based on what you observed on those videos, do you think there's anything Haneen tells you that is plainly reliable or that doesn't speak to her parents' behalf, regardless of what information she says? Do you think there's anything? She's not there for the striking of her dad, yet she immediately shows up and starts telling law enforcement when they're there, they're hitting my dad, it's all on my video. She doesn't have a video of anyone hitting her dad. She's not even there when that happens. Do you think Haneen becomes a reliable witness to hear anything from? I submit to you that she would not be. When she goes to check on her child at the office, as Mr. Leary said, her first instinct is to go run and check on her child. The amount of time she spends in that school is grossly less than the amount of time she spends trying to get to her husband and screaming. Remember what Officer Bell's and Officer Chavez's cameras looked like. Screaming over and over again, you let him go, he did nothing wrong, you let him go, over and over. Her interaction, look at her demeanor and her body language when she gets in the school. It's angry pointing is what I submit to you. When she leaves that school, it is angry pointing at Mr. Dean. Then she turns around and she's gone. That's it. Remember what Officer Chavez says. I told her EMS was working on her child. What was her response? She didn't have one. No response. So where is this motherly concern that we keep hearing about for Fatima? I submit to you it doesn't exist. It's not there. Fatima told you that she could not breathe. She told Liz Robinson that she could not breathe, and that is consistent with what the other individuals that were present who identified it, because certainly some people said, I didn't see it. Listen, Mr. Denicola said, I saw mom grab, or who I assumed was mom, but then my focus was on dad. That's where I thought the immediate threat was. And Josh Wagner says, I'm staring at dad. This is where my focus is. I know something's over here, but this is my focus. So the people that are actually paying attention, at some point, even Isaiah says initially he's not looking at it. And you can see in the video, they're watching dad, because who expects mom to come in as an additional threat? They're not anticipating that until it actually happens, and now they have to intervene. And they immediately, when it happens, start talking about it. Athena says, you can't do that. Like, why are you grabbing her around the throat? You can't do that. Fatima says, I can't breathe. You hear Noah Wagner from across the let go of her. It's done. At that point, Wagner is already on down. So let go of her is only directed at mom. He's watching it happen in real time. So you absolutely have the individuals that are seeing these things as they are occurring, because they are far enough back to identify that. When we talk about crimes and the burglary, as we pointed out, as the state pointed out to you in your instructions, in order for something to be a burglary, you have to enter a building. So yes, a criminal trespass also occurred, but a burglary in the second degree occurs when she enters a building. Just like when she assaults her, that is also an assault in the fourth degree, but it is not only an assault in the fourth degree, and we talked about that. So that argument by defense counsel, well, you could have done this for criminal trespass, we could have also done that. It would have been yet another crime, and instead we didn't. We went with when she entered the building, which she is prohibited from doing. There is no requirement, and you won't find it in your jury instructions, that you have to receive your document in the language of your choosing. That is not how the law works. If you went to, let's say, France, and you got an order or a ticket from France, you wouldn't get to say, I don't know what this says. I get to ignore it. I'm not responsible for it. That's not how the law works. You don't get to create ignorance for your benefit. You are still subject to the laws of the state of Washington.
I'm going to object, Your Honor, as to misstating the definition of knowingly.
Definition is what?
Knowingly.
Haven't talked about knowingly.
I'm going to have a brief sidebar with the lawyers, and so you can stand and take another little move around break.
Interesting. Sidebar. What was she talking about? She was talking about they're hitting my dad. It's all in the video. Wait. I missed. What are they talking? Whoa. Let me go back to that. Is it misstating? Hold on.
We're still subject to the laws of the state of Washington. Get to create
Oh, the ticket.
for your benefit.
So the
We're
one-way
still
ticket.
Subject to the laws of the state of Washington. And
Misstating the law. Okay, so they're arguing that she, or the sidebar, yeah, they're arguing that she misstating the laws of Washington.
Break. Please be seated. In just one moment. Okay, we just had a sidebar after Mr. Larry's objection. The objection is really a misstatement of the law. We got to sidebar. Mr. Larry made a very short argument as it related to his objection. Ms. Stone started to respond, and then I just stopped the sidebar and said instead we'd have it on the record. So I am not summarizing verbatim what was argued at sidebar because I'm not going to rely on that. I will just have the argument here in open court. Anything to add to that, Mr. Larry? The sidebar itself?
Instruction 48.
Nope. Anything first to add to the sidebar?
No.
Mr. Kading? Ms. Stone?
No, Your Honor.
All right, go ahead.
Okay, thank you, Your Honor. So instruction 48 is the to convict for violation of a court order. Prong 3 says that on or about the said date, the defendant knowingly violated a restraint provision of the order prohibiting contact with a protected party. It's the state's burden to prove beyond a reasonable doubt each and every element. And so prong 3 is the burden on the state to establish that the defendant knowingly violated a restraint provision. My argument in my closing was that she was presented an order in a language that there's testimony from her daughter that she does not read. And the state in rebuttal argued that the defense doesn't get to argue that it was written in the wrong language. The state said there was nothing in the instructions that said that the order had to be written in her language, and used the analogy that if one of us was to go to France, we wouldn't be able to say that we have ignorance of the law because we don't speak French. The problem here is my client's not claiming innocent or ignorance of the law. The specific issue is the state has to establish a knowing violation of a restraint provision, and if it is contained in a document that there's testimony that she doesn't understand, the state hasn't established that it's a knowing violation. And to assert that somehow it's our job to prove, or it's somehow wrong for the defense to argue that because it was written not in Arabic, that it's an invalid defense. This goes squarely to whether the state has established beyond a reasonable doubt the knowingly violated. And to undercut that diminishes their burden of proof, the presumption of innocence, and shifts the burden to us, and all three are improper.
Thank you. Ms. Stone?
Thank you, Your Honor. Your Honor, first of all, I wasn't done making my argument. I was partway into my argument when counsel raised the issue, so it's unclear to the state how counsel can complain that the state hasn't made an appropriate argument when it hasn't let the state make, in fact, the argument. Second of all, he says very specifically during his closing that one of the ways that he is demonstrating that the state cannot prove that the defendant knew because it wasn't written in their language, as in specifically Arabic, her first choice of language. This is a direct response to that argument made by the defense, which the state is entitled to do. There are, in fact, additional arguments I'm making along with this same line that go to that, but the state has not yet once misstated the obligation of the state as it relates to knowledge. I am talking about a piece of evidence that defense counsel presented, and I am responding to that directly and tying it into knowledge, which still has a significant amount of argument to go from the state. So at this point, not only is his objection not consistent with what the state's arguments have been, it is untimely because the state has not in fact finished that argument, and it is improper because the state is entitled to respond in rebuttal to these specific arguments that defense counsel has made, which is, well, if it's not essentially in her preferred language, then how can the state possibly show that she knew, and so she can't be held accountable for knowing? The state can't prove that because it wasn't in the language that she preferred. Those are all appropriate arguments for the state to respond to, and I was in the process of doing so when defense counsel untimely objected to the course of that argument.
Mr. Leary, anything further?
I would just note that it's not her preferred language, it's that it was written in a language that the testimony is that she doesn't read.
All right, I'm going to overrule the objection. I do not find that the argument that was made by Ms. Stone misstates the law as contained in the jury instructions and does not shift the burden of proof to Mrs. Ali in any fashion. And so please bring the jury in. Please be seated. I am overruling the objection. Ms. Stone, you may continue.
Thank you, Your Honor. So back to what we were talking about. You're not going to find in your jury instructions the requirement that any order be written in any particular language in order to establish knowledge. That is simply not the requirement. The state has to show that the defendant knew it, and you have been given sufficient and ample and overwhelming amount of evidence that she did. Specifically, she was offered the opportunity for an interpreter, and she declined that during the course of the trespass order service. She was then asked for Haneen expressly to be provided so that she could be aware of what the limitations were during the trespass order notice. Again, during the no contact order, as you see, she specifically wants Haneen there, and you see Haneen ask the officer, "Are you okay if I'm here?" She likes to have me present, essentially, words to that effect, so that I can help her with this. And she says, yes. Counsel continued to tell you that the testimony from Fatima was that her mom doesn't read English. That was not Fatima's testimony, I submit to you. Fatima's testimony was she doesn't read it well, and she certainly doesn't read it as well as she speaks it, but Haneen usually helps her, and that is in fact her preferred version of that. You heard the school talk about they've had communications with mom. Those communications are consistently in English, so she absolutely is able to move around her universe in English. The expectation is that you are obligated to follow the laws of the state of Washington, regardless of what your first and preferred language is. I want to be very clear. That does not mean that somehow makes it easier for you. Mr. Leary made a big argument, I'll choose the word argument, at the end, that somehow Mrs. Ali, and Mr. Ali are being specifically targeted for some reason other than what their actions are. The laws of the state of Washington apply to them equally. Their actions are what are on trial not them as humans, not them as people. You don't sit here as judges of character. That's not what your purpose is. You are here to determine if the actions that they took on October 18th, 2024 are consistent or inconsistent with the law, as the court has instructed you, and whether the state has proven that to you beyond a reasonable doubt, not whether you personally agree or disagree with anything about either one of them. That is not the standard, and you absolutely should not be doing that. We don't decide cases based on sympathy or prejudice. You absolutely should not be doing that. We decide cases based on evidence. This is a court of law, not a court of feelings. And so I would ask you to return to your instructions. Somehow, Mrs. Ali speaking a different language, it may impact your decision or your evaluation process in terms of knowledge, but likewise, the additional assistance that she was provided and offered, that she accepted, and the assistance that she declined demonstrates to you in how she interacted with both law enforcement and the school as to both of those orders, that she understood absolutely what the parameters were for what behaviors she was allowed to do and which ones she was not allowed to do. And she knows she's not supposed to be in that school. Absolutely knows she's not supposed to be there on October 18th. But she goes in anyway because she says Isaiah took her child and go, and they went in there, run away. So she wants to go get her child back from Isaiah, and she is not allowed to do so when she gets in there by the faculty. She is prohibited from doing so when she gets in there by the faculty. When we talk about the behaviors actually at the scene of mom, again, Mr. Leary is described it like she is comforting her child. That's what she's there for. But you heard Fatima say, that's not what we do. There's no hugging in my family. Like, not just like, hey, it's only occasional here and there. There's no hugging in my family. That is what Fatima said. These are not arms that reach around and comfort her child. This is a different kind of hold. This is a restraint. This is a choking around the neck. And Fatima says immediately, I can't breathe. And Denicola says, I can hear her whispering something, but it's not coming out, right? Remember Athena's testimony also saying, I remember her saying, my husband, as it's happening. That's what I remember. Not my daughter. And we know at the time, as we talked about before, Fatima has been isolated significantly at the time that contact is made. So when she runs into the school, again, mom is chasing her down and trying to pull her back. So the 4 weeks of isolation that she has had leading up to this one-way ticket out of the country, mom wants her back. Mom doesn't want her to talk to law enforcement, I submit to you, doesn't want her to talk to the school officials anymore. And that is what she is concerned about. Remember, she says, just let me talk to her. I just want to talk to her for 1 minute. That's what she's telling Officer Chavez. Not how is she, what is she doing? Just let me talk to her for 1 minute. Does that sound like a mom that wants to know about the condition of her child? Or does that sound like a mom who wants to make sure that she and her child are on the same page and they are able to get their story straight? So then let's go to Mr. Kading's arguments. Mr. Kading over and over again says, when my client was unconscious, my client had this head trauma, and my client had all of these things wrong with him. You heard no evidence of that. In fact, you heard Isaiah say, I thought he went unconscious, and when asked, is that something you did or is that something that happens later? He says, well, when we were striking him, nothing happened. Eventually, his eyes closed. And when is that? Well, Mr. Wagner was the one and he doesn't know his name, Mr. Wagner. He says, not the adult, not the bus guy. the other guy, when that guy gets there, everything stops. And Josh Wagner says, when he gets there, his eyes are open, he is choking that child, he is strangling that child, and when Josh Wagner does whatever special operations maneuver Josh Wagner does, that is when he releases. And everyone agrees with that. Denicola says, I'm trying to get his hands apart, but I'm not successful. I'm doing it on my own. And then another guy shows up at the same time. They all talk about the third individual that is present but has really no interaction, and you see that guy in the blue coat come running from the elementary school across the street. But about the time that Wagner is on top of Mr. Ali, that is the same time that Denicola is down there pulling at the hands. And I submit to you, those things happen at approximately the same time. But each of those kids indicate his eyes are wide open. Remember what Denicola says, the look on his face. This is not an individual who is unconscious and strangling. It's not an individual where there's any indication of head trauma. And Mr. Kading said, well, they didn't even check. Right, because he said he didn't need any. How in the world, why would they check for a head trauma when they've identified, would you like any medical? Do you need any medical? No. Because there's nothing wrong with Mr. Ali. There's no cerebral anything. There's no loss of consciousness. And remember what Dr. Gilbert says, when you lose consciousness, you lose control of your body. And you see exactly what happens when you lose consciousness. When you watch the video of Fatima, you go limp. Everything relaxes. You go limp. You heard Lisa Wall talk about that. When you lose consciousness, you relax, which is what makes strangulation even more dangerous when you lose consciousness, because all of your muscles relax. You know what your muscles don't do? They don't hold on and pull even tighter. The scenario that Mr. Kading offered you over and over again is not reflected in the evidence in any way. Everyone that described how Mr. Ali was holding his daughter describes it in, right to left, describes it in a headlock, a rear naked choke, armbar, and it's pinched back. Every single person did this. If he is unconscious, it all drops. It all lets go. And you didn't see that once. And when you listen to them talk about it, there's not a single person that says it looked like it was involuntary, that it was not intentional, that it was anything other than exactly what it was. He was angry, and the look on his face says so. He is intending to do those behaviors. Intent is reflected, I submit to you, by action. A lot of people can say a lot of things, but what we should be evaluating people are the actions that they take. And the actions, the force used by Mr. Ali was with the intent to murder his daughter. That action is taken, that intent can be formed at any point during the course of that. He does not simply walk over as his daughter is trying to run away from him and grab her by the wrists to take her home. That's not what he does. You see him in that video, and I'm not sure, Mr. Kading played it multiple times, and we must be watching a very different video, because when he says, look, he's just grabbing her, right, around the neck. She's bent down, and he immediately goes around her neck and immediately grabs her and maintains that hold on her throughout. So that is absolutely what he's doing. He is strangling her from the get-go. Isaiah and Caleb, those kids are watching, and they immediately know what's going on. And they immediately know that this is wrong. You actually see at one point, Fatima, as they're starting to go back, her hands are here, and she's already at the neck. Her hands are already up, because that's where his arms are. The kids see that too. So no, they're not attacking. This is not some mob that is beating up where Mr. Ali somehow is the victim in this case. Mr. Ali instigated this. He initiated these whole series of events, and he strangled his child in front of a large group of other children who know exactly what they saw when they saw it. And as kids, knew that Fatima was in danger and had to intervene. That's what they were doing. They're not the initial aggressors. Mr. Ali is. He's not defending himself against Isaiah. He immediately grabs, as all of those kids described, Fatima aggressively. And Isaiah knows, because he has the historical background on this family. He's not simply taking Fatima's words for what has been going on. And he told you that. I know what happens. I've seen my own information to corroborate what Fatima has told me. He's also had his own experience with mom to corroborate what Fatima has told him. He knows that the school has taken these efforts. If you're a kid and the school has taken these efforts, might that also indicate to you that those safety concerns have been corroborated? So no, it's not just Fatima making statements and everybody just taking her word for it. Those statements have real value. And the people that are involved or subject to them, I submit to you, know when danger is most likely to them based on their relationships with the people that they are involved with. The school doesn't call her parents, and the school doesn't call her parents because they have a safety concern. So in what world would you, as a official who has a history of interacting with a child, call the person to let them know that you found their child so that they can come home and take them when you have a safety concern? Ms. Robinson said it wasn't imminent, and then she described imminent means like he's not strangling her right in front of me. I don't need to call 911 at the moment because he's not right here, but we can make another set of arrangements for her. Absolutely appropriate. When they talked about, when Mr. Kading talked about, well, Isaiah hit him because he was mad. Isaiah said, I mean, I was mad, yeah, after I got punched, as I think is a reasonable, I submit to you, is a reasonable response. He doesn't say, I went and attacked him because I was mad. The question was, well, when Mr. Ali punched you, you were mad, weren't you? And he was like, yeah. That is an absolutely reasonable response for a kid to say, this adult punched me in the side of the head. He was trying to attack his daughter. I was trying to intervene to keep her safe, which Isaiah is also entitled to do. And the defendant punched me in the side of the head. So yeah, I was kind of mad about it. Fair. But then when he stumbles back, and you see how far in the video from the front of the bus, how far he stumbles as a result of that, he stands back up, he looks around, and Dad is already taking Fatima into a headlock and a chokehold. So when they go, they're not going over the push him down and start kicking him. They're trying to get Fatima out. And to be fair, they're kids. So if we're arguing that the execution of said non-existent plan by kids wasn't the greatest execution, that's probably a fair statement. But it doesn't mean the intent is any different, right? It's very clear that they're all screaming, they're all kicking, and despite all of that, Dad doesn't release. Even when Mr. Denicola is there yelling about it, even when Mr. Wagner shows up. That is not, those injuries to Fatima are not because they're just wrestling on the ground and he's trying to protect her. Nothing about what he is doing is trying to protect her, and you have that testimony. And you have the description of the injuries. That armbar hold that was described to you, that is very specific. That's not simply hands. It's not like, oh, we all got caught up and we were all tangled. It was this, and he was locked in. And Mr. Denicola described it as his hands were tied together and he could not even pry his fingers apart. He was actively resisting having his fingers pried apart. Defense counsel argued that all of these kids had all watched the video. All these people had come in and they'd spent all this time testifying about the video, and so therefore that's why all of their testimony was the same. Ladies and gentlemen, that is akin to interviewing people that have left the Grand Canyon and taking issue with the fact that they all called it real big. They all described what they saw. They described her going pale. They described her lips going blue. They described her, two of them saw her seizing, what Dr. Gilbert would describe as seizing. They don't know that that's what they're seeing, but that's what they've described. They've described her being unconscious. All of those things are described to you because that's what they observed, and from their vantage points. And some of them didn't describe things that other people identified. And to that end, Mr. Denicola and Mr. Wagner and Mary Wagner also didn't describe all of the same things. But the things they did describe that were the same, that overlap, is because that's what happened, and that is consistent with the video. So statements to the contrary don't make any sense, right? We've described, you heard Fatima say she thinks as she's coming into this conversation, it's calm, but all of the other students are watching and they're like, it looked really angry and aggressive to me. So what does that tell you about the environment that Fatima is in? That what feels like a calm conversation to her with her dad is described otherwise by the objective observers watching, that is not calm. You have evidence of the intent for days. And Mr. Kading said, there's no evidence of any intent here. You do. And the actions are, in fact, the evidence of your intent. When you look at that assault 1, for example, it says that whether the defendant acted with the intent. And if you walked up and somebody was strangling someone into unconsciousness in that same type of hold, and they said, don't worry, it's fine, I'm not trying to kill him. Don't worry, it's fine, I'm not trying to hurt him, they're fine. And you've watched their lips go blue, and you've watched their eyes roll back in their head, and you've watched them seize, would those words mean anything to you? I'd submit that they would not. You would not believe that because of what you were observing with your eyes about the acts themselves. They speak louder than any words that Mr. Ali could have provided at the time. Don't get caught, please, into the idea for great bodily harm under assault in the first degree. The great bodily harm has to be inflicted. That is not the instruction to you. The instruction to you is that the force used must be likely to cause great bodily harm or death. That the force used. And you have an overwhelming amount of evidence of that specifically. Mr. Ali knows exactly who these individuals are. He's spoken with Mr. Barnes. They've spoken about Fatima and Isaiah specifically. He knows that his wife is subject to, I submit to you, a no contact order with Isaiah.
I'm going to sustain the objection.
He knows who these individuals are.
Objection, Your Honor.
Overruled.
He knows who these individuals are. He's spoken with Mr. Barnes. He knows that Fatima is in a relationship. In fact, he's told, and Mr. Barnes testified about that. He said, I'll do my best. We can try and keep these kids apart. That's what Mr. Barnes told you. But what are we gonna do? Like, they're in love, but I want to be respectful, and I want your wife to stay away from my son. That was his testimony on the stand. And then as they're standing there, Isaiah is rubbing her back and essentially saying, it's okay, right? And you heard Noah's testimony. Noah says, I said, inshallah, it's love. What are you going to do? They're in love. And that he did not like that. Mr. Ali did not like that. He knows exactly. There's no indication here that Mr. Ali is dense and he doesn't recognize contextual clues, especially when there's been a direct conversation about it. That information is all information that Mr. Ali has. So if anyone also is directly under the point of Mr. Ali's ire, again, that would be Isaiah. So do you think that punch then is delivered with a bit more force because of who it is being delivered to versus a push? Maybe the reasonable alternative is a push to that. But he doesn't do that. He punches him in the head. And again, why? Because he's mad. The standard for reasonable doubt is not a doubt. It's not a single doubt. That's not the standard. That is a misstatement, in fact, of that law. Go back to your instructions. The standard is whether it is a reasonable doubt, not any possibility, not any doubt. And in fact, if you have an abiding belief in the truth of the charges, then you don't have a reasonable doubt. When you came into this case, you didn't know anything about the facts whatsoever. You knew nothing. So if you're coming to that place now where you're like, I believe that I have an abiding belief in the truth of the charges, that the state has proven that to me beyond a reasonable doubt, then I submit to you I have met my burden. Certainly do not lower the burden of the state, but also don't make it greater than what it actually is. And that is the instruction before you. Not any doubt, not a single doubt, but a reasonable doubt. Counsel used the the example of making a basketball hoop. So he must have intended it, that you can only intend a strangulation by putting your hands. Anything else, bless you, anything else is not evidence of intention. I submit to you it is a strange or maybe even an absurd scenario where somebody whoops-a-daisies their way into an armbar hold, a rear naked choke. That's not an accidental event. That is a exceptionally intentional event. You can be, let me back up. Defense counsel said, these are parents they're at the end with Fatima. They're struggled, they've had a hard time. As I said during my first closing, everyone can relate to that, right? Parenting is hard, and that people derive sympathy from that, and we certainly, individuals can understand that. But it does not matter for the purpose of this trial as it relates to the actions that those defendants took. You can be the worst kid in the absolute world, and it still wouldn't justify what these two parents did to Fatima on that day. You do not get to strangle your child. You just don't. So that is, parental discipline does not allow for that. Parents have a lot of leeway, and I would argue that's probably true across the country, but in the state of Washington, parents have a lot of leeway in how they restrain and discipline their child. But those rights are not unabridged. You don't get to do whatever you want and then couch it under the guise of parental discipline. And here, Mr. and Mrs. Ali grossly exceeded what that looks like. Fatima was strangled for approximately 45 seconds. And if you think about how long 45 seconds is for somebody who hasn't taken a breath, they weren't anticipating holding their breath, they weren't anticipating being strangled, and it's not just holding their breath, but there's additional pressure and panic occurring at the time. 45 seconds is a really long time. So let's count it out. That's 45 seconds. That's how long her dad was strangling her. It's a really long time, you guys. School is supposed to be a safe place for kids. It's a safe place for Fatima. She told you that when she testified. She's known adults and other students there for 2 years. She's formed relationships with those adults. The school told you they had concerns about Fatima being online and not having access to other adults. These are the same adults, Tracy Arnold testified, that told you they would feed her, they would give her snacks. When Fatima shows up at school that morning, she leaves the house at 4 or 5 a.m. and she just essentially waits, does circles until school opens up. She testified about that. And as soon as school opens up, she goes in. That's where she goes. She doesn't go somewhere else. She doesn't get on a bus to Disneyland. She doesn't do something else. She goes to the school. And defense counsel says she ran straight to Isaiah. She ran straight to Mr. Thomas. That was her first period teacher. Also Isaiah. That's where her safe people were in that class. She goes to her first period class, to her safe people, her safe adults. And she talks to Mr. Thomas first. Remember, Mr. Thomas calls Isaiah out of class. Mr. Thomas goes and gets her snacks, brings them out to her, and then sends her to go see the counselors. And that's where she spends the rest of that day. She knows these adults, she trusts these adults, and her parents know that about her. We tell our kids to tell someone when they don't feel safe. We tell them to find a safe adult. Tell your teacher, tell your counselor, tell someone outside of your home. And that is exactly what Fatima did on October 18th of 2024. She has been characterized throughout this trial as just an angsty, bratty teenager who just didn't want to go on a family trip. That could not be farther from the truth. She did not just want to hang out with her boyfriend. She showed up, she flees her house, she hides, she goes directly to the school, she tells the school that she needs help. What evidence is there that the things she testified about on that day were a lie? What about that video that you watched, we've now all watched repeatedly, was a lie? Was there anything about that video that she said didn't happen that was a lie that you saw? I submit to you that there was not. Fatima said she was not safe. That's what she said. I didn't feel safe. I don't feel safe. I told the school I didn't feel safe. Isaiah knew I didn't feel safe. 6.5 hours later, her parents showed up and proved she was correct. So where is the lie in that? She was most certainly not safe. I'd ask you to return verdicts of guilty. Thank you.
Thank you. Members of the jury, in just a moment, the bailiffs are going to come forward and lead you back to the jury room. When you return to the jury room, the 2 alternate jurors who are remaining will take their belongings and they will be leaving. But I will tell both of the alternate jurors I have not and do not release you from the instructions that I have given you. You are still prohibited from discussing this case from anyone seeking out information, be exposed to information, and the like. Once the trial is concluded, the bailiff will reach out to you and let you know that the case is concluded, and at that time you will be released from my instructions. If something happens during the jury deliberation process and one of the 12 is unable to continue, number 2 would be called back, join the group, and deliberations start all over again. And same would be if we had 2 people, then alternate number 3 could still be called back, and that's why you are not released from your instructions in any way. And I want to truly, if I don't see you again, thank you so much for your service. For the 12 of you who are going to be going back to the jury room, it is 4:10. What you need to do today is you need to select your presiding juror, and then you need to decide what time you're coming back tomorrow morning, either at 8:30 or 9 o'clock, to begin your deliberations. I'd be sending you home at 4:30, so I don't want you to start your deliberations. Select your presiding juror and select the time that you are coming back tomorrow. All of your instructions remain. You are not to seek out information. You are not to talk about this case with anyone. The only time you can deliberate is when all 12 of you are in the room together for deliberations. So you can't call each other in the middle of the night because it's deliberation time. It's very, very important. So please continue, of course, to follow my instructions. Thank you very much for your time and attention this morning. The bailiffs will lead you back. Please be seated. If you have not done so already, if you will provide your contact information to the clerk, please, in case we have a question, or ultimately if we have a verdict. Mr. Kading and Mr. Leary, I ask that you stay within about 10 or 15 minutes from the courthouse so that you can return as soon as possible if we have a question. I will say that we should not have a lot of questions because I think the lawyers did a nice job during closing of by telling the jurors a lot of what our common questions are. But we could have questions, so I would like people to be readily available. The jury is going to select their presiding juror and then select when they are going to return tomorrow. And as I told them, they can determine that they will start at 8:30 or 9 o'clock tomorrow. And then we will wait to hear from them. Ms. Stone, do you have any questions?
I do not, Your Honor. Thank you.
Mr. Kading?
No, thank you.
Mr. Leary? All right, so we will be in recess until such time as either we have a question from the jury or if they indicate that they have reached a verdict. Thank you. All rise, court's in recess.
All right, so that's that. But let's go through what we heard before we let you guys go, before class is dismissed. All right, come here. All right, so they thank you, Kate. Thank you, Forrest. Appreciate you. Thank you so much, Forrest. I can't pull up your chats. I'm sorry, you guys. Kate, member of Rabbit Ears for 2 months. Good night. Thank you all. Forrest Nelson, 20 Canadian. Thank you. Squeegee and Mods, always nice to spend time here. Appreciate you. When we lost power, around 3 o'clock, and then I had to scramble to get this next feed up. I didn't get my chat to be able to pull up. So I can't pull your comments up. But thank you, Forrest. And thank you, Kate. And thank you, guys. Thank you, everybody that has been here with us. So let's do a quick recap here. We did, let's go back, let's see. So whose closing was more credible? Prosecution, Heather Stone, 90%. Timothy Leary, 7%. He's the defense for Zahraa. And 1% thought Eric Keating for Ihsan. 1% of you thought that Eric Keating was more credible. So then the state had a rebuttal. I thought she had some really good rebuttals. I'm going to go ahead and talk you through it. So she's like, how did we get here? From Mr. Leary. Leary was saying what she was thinking, and you don't weigh that. You look at the actions and the evidence, not what she was thinking. You heard from Fatima. Her fears were real. She said there was a one-way ticket. She said, I'm going to a country I don't feel safe, and there may be family there, but they don't support me. This is what she's saying. Hold on, let me just do one thing. This poor kid had a lot of fears. For a 17-year-old, that was very concerning based on her experiences. How does she come to the school and then get out and run to the scene? So now she's talking about Zahraa. So how does she know to come to the school? Dad communicated to her, right? So how does she know to come to the school and then run immediately to that scene? So Dad must have said, hey, they're at the bus stop. I'm going to go do something, right? If your first response is to aid the dad and not her daughter, that's a substantial step in being an accomplice. And then she goes into the daughter, Haneen. Do you think Haneen would be reliable on the stand? Not based on what we saw. She said, they're hitting my dad. It's all on my video, which truly was not the case. Then we get a sidebar, and it was misstating the laws of Washington. Then they brought it back on the record. So Mr. Leary said, Ms. Stone said something to the judge. I want to have it on the record. So instruction 88, violating the restraint provision. the testimony from the daughter that she doesn't read English. She used an analogy as if we go to France, we can't be ignorant of the law because we can't read French. So then Ms. Stone said, well, I wasn't through making my argument. My direct response was to defense's argument that Mrs. Ali can't read English. The objection is not relevant because it's not consistent, and I'm not even finished with my argument yet. So the judge ultimately overruled that objection. I'll call that one. That's about as snarky as she got. But the laws apply to them as much as anyone else, right? So, then the assistance she accepted and declined as she understood very clearly, and she knows she shouldn't be at that school. And she says, this is not a person hugging her child. These were choking arms. When you lose consciousness, you relax, and it's even more dangerous, right? Because you're not clenching up. You're even more. You're more relaxed and.